Good evening. We begin tonight with a major legal development involving the President of the United States and the highest court in the country. The Supreme Court has rejected an emergency filing that sought to halt civil asset seizure proceedings authorized by the state of New York. The ruling, issued Friday evening, denies a request made by President Donald Trump to block enforcement actions tied to a civil fraud judgment against the Trump Organization. According to the court's order, the application for an emergency stay was denied by a vote of 7-2. The decision leaves in place New York's authority to proceed with enforcement measures, including the liquidation and seizure of assets connected to the judgment. The order was issued at 6:34 p.m. Eastern Standard Time on Friday, January 23, 2026. It consists of a brief written ruling, accompanied by a concurring opinion from the Chief Justice and a dissent joined by 2 justices. With this denial, the filing described by Trump's legal team as a final attempt to prevent immediate enforcement has failed. As a result, state officials have confirmed that asset seizure proceedings are scheduled to begin on Monday morning, January 26th at 8 a.m., pending no further legal intervention. According to statements cited in the filing and in subsequent confirmations from law enforcement officials, the New York City Sheriff's Office is prepared to initiate enforcement actions authorized by the court. These actions include the appointment of receivers to take control of specified commercial properties and the freezing and transfer of financial accounts associated with Trump Organization entities. Officials have indicated that these steps will move forward unless interrupted by a new court order, and no such mechanism remains available following the Supreme Court's decision. The emergency application denied by the court was filed earlier in the week, following the collapse of a bonding arrangement and a New York court's authorization, allowing the state to begin collecting on the civil fraud judgment. Trump's attorneys submitted the application directly to the Supreme Court on Wednesday, January 21st. Under court procedure, the filing was initially directed to the justice assigned to oversee matters from the Second Circuit, which includes New York. That justice referred the application to the full court, citing the constitutional questions raised in the request. In the application, Trump's legal team argued that subjecting a sitting president to civil asset seizure during his term in office violates constitutional principles, including the separation of powers. The filing contended that enforcement actions by a state government could interfere with the president's ability to carry out executive responsibilities. According to the argument, the seizure of personal and business assets during a presidency would create distractions and impair the functioning of the executive branch. The attorneys maintained that such actions should be delayed until the conclusion of a president's term. The application also raised claims related to executive privilege and national security. Trump's lawyers argued that a president's financial stability is closely tied to his capacity to conduct foreign policy and protect national interests. They asserted that financial vulnerability could expose a president to undue influence or exploitation by foreign actors. Additionally, the filing invoked the political question doctrine, arguing that disputes over a president's alleged misconduct should be resolved through political processes such as elections or impeachment, rather than through state-level civil enforcement. In response, the New York Attorney General submitted an opposition brief disputing those claims. The state argued that the president is not immune from civil enforcement actions and that no constitutional provision grants temporary protection from such proceedings based solely on holding office. The brief stated that the president had chosen to retain his business interests while serving in office and had declined to place those assets in a blind trust or divest from them. According to the state's filing, those decisions carry legal consequences that are not suspended by the presidency. The opposition further cited historical precedent, noting that prior presidents had faced civil litigation, investigations, and legal pressure while in office. The state argued that the Constitution does not place the president above the law and that immunity from criminal prosecution, which remains a contested issue, does not extend to civil liability or enforcement of lawful judgments. The brief warned that granting the requested stay would create a loophole allowing presidents to avoid financial accountability while in office. After expedited consideration, the Supreme Court denied the emergency application. In its order, the court stated that a sitting president does not enjoy immunity from lawful civil enforcement actions by state governments. The court noted that while the presidency carries unique responsibilities, those responsibilities do not exempt the president from obligations that apply to other citizens. The order emphasized that the enforcement actions at issue were the result of judicial proceedings that had already concluded and that the president had opportunities to avoid the outcome through different choices. The Chief Justice wrote a concurring opinion underscoring the judiciary's role in upholding the rule of law. In that opinion, the Chief Justice stated that the courts are not tasked with shielding powerful individuals from accountability. He warned that granting the requested relief could undermine public confidence in the legal system by suggesting that presidents are treated differently under the law. While acknowledging that asset seizure during a presidency is unusual, the opinion stated that such circumstances arose from the president's own decisions regarding his business interests. Two justices dissented, expressing concern about the potential for state governments to use civil enforcement actions to target sitting presidents. The dissent argued that the court should have granted a temporary stay to allow for fuller consideration of the constitutional questions raised. However, the dissent also acknowledged the factual findings underlying the fraud judgment and noted that the president's refusal to divest from his business holdings complicated the constitutional analysis. With the Supreme Court's decision now final, there are no remaining appeals available to block enforcement. State officials have confirmed that preparations are underway to execute the judgment. According to information provided by law enforcement and court filings, these actions will begin at the start of the next business week. The scope and speed of the enforcement process have drawn significant attention due to the scale of the assets involved and the unprecedented nature of applying such measures to a sitting president's business empire. As this ruling takes effect, attention now turns to what will occur once enforcement begins and how the process will unfold on the ground. In the next part of our coverage, we will detail the specific steps outlined in the enforcement timeline and explain how state authorities plan to carry out the courts, as well as the immediate financial and operational consequences that follow. As enforcement now moves from the courtroom to direct action, attention is focused on how the state of New York plans to execute the civil judgment authorized by its courts. According to information cited from officials within the New York Attorney General's office and operational details referenced in the record, the enforcement process is structured around a rapid and tightly controlled timeline designed to convert assets into cash and secure funds owed under the judgment. These actions are set to begin on Monday morning, January 26th, and will unfold over the course of several days. The first phase begins at 8 a.m. Monday, when the New York City Sheriff's Office is scheduled to serve a formal notice of levy at the property located at 40 Wall Street. That notice formally initiates the transfer of operational control from the Trump Organization to a court-appointed receiver. The receiver named in the order is Margaret Chen, a forensic accountant and asset management specialist with experience handling complex commercial seizures. According to court documents, her role is to take immediate control of the property, secure its finances, and ensure that all revenue generated is redirected in accordance with the judgment. Upon arrival, the receiver is authorized to present the court order to building management and assume authority over day-to-day operations. Employees of the Trump Organization working at the property are informed that they no longer report to Trump or his company, but instead to the receiver, acting on behalf of the court. Financial records are transferred to the receiver's team, and access to bank accounts previously controlled by Trump Organization personnel is revoked. Rent collection systems are modified so that payments are directed into a court-controlled escrow account rather than to Trump Organization accounts. Tenants in the building receive written notices explaining the change in control and instructing them on where future rent payments must be sent. According to the enforcement plan, tenants who fail to comply and continue paying the Trump Organization may face penalties for violating the court order. By midday Monday, the receiver is expected to have full operational control of the property, including oversight of maintenance, staffing, and financial flows. Revenue generated by the building, previously associated with the Trump Organization, is redirected to the state as part of the enforcement process. Later on Monday, at approximately 1 p.m., the Sheriff's Office is scheduled to serve restraining notices on multiple banks operating within New York. These notices identify dozens of bank accounts linked to Trump Organization entities. Upon service, the accounts are frozen, preventing withdrawals or transfers by Trump or affiliated personnel. The banks are given a defined period to calculate balances and prepare for turnover orders requiring the funds to be transferred to state-controlled accounts. Estimates cited in the enforcement materials indicate that these accounts collectively contain tens of millions of dollars in liquid assets. The freezing of these accounts has immediate operational consequences. According to the filings, the funds include operating capital used for payroll, property maintenance, and other routine expenses. Once frozen, those funds are no longer accessible to the Trump Organization, significantly limiting its ability to function. The enforcement plan anticipates that these measures will take effect simultaneously across all identified institutions to prevent the movement of funds in advance of turnover. The following day, Tuesday, January 27th, marks the next stage of enforcement. At 9 a.m., a second receiver is appointed to oversee commercial components of Tower. The receiver named in that order is David Rosenberg, a real estate attorney with experience managing high-value receiverships. His mandate includes assuming control of retail, office, and common areas within the building, as well as managing relationships with tenants. According to the plan, Rosenberg and his team are authorized to enter the premises, post official notices, and distribute written instructions to tenants and vendors. Retail operators, office tenants, and service providers are informed that ownership control has shifted and that all payments must be made to the receiver, rather than to Trump Organization entities. Employees working within Trump Tower are similarly notified of the change in authority. Court documents indicate that the receiver has the authority to terminate employees who refuse to comply with the receivership or obstruct its operations. This authority is intended to ensure continuity of operations and prevent interference with the enforcement process. By the end of Tuesday, the receivership is expected to be fully established, with financial flows redirected and operational oversight transferred to the court-appointed manager. On Wednesday morning, January 28th, the enforcement process reaches another critical point. Banks subject to restraining notices complete their calculations and prepare to comply with turnover orders. These orders require that frozen funds be transferred directly to an escrow account controlled by the New York State Department of Law. According to the information cited, the transfer of these funds occurs in a single coordinated action, resulting in the immediate loss of liquidity for the Trump Organization. The removal of these funds has cascading effects. Without access to operating capital, the organization is unable to meet payroll obligations, service debt, or cover routine expenses. Court filings describe this stage as effectively rendering the organization insolvent, at least in the short term, as cash flow is interrupted and financial control is transferred to the state. That same day, additional actions are initiated involving real estate assets outside New York City. One such property is the Seven Springs estate. Under the authority granted by the court, the receiver overseeing that asset lists it for sale at a price below its most recent appraisal. The stated objective of the sale, according to enforcement documents, is not to maximize long-term value but to convert the asset into cash efficiently, to satisfy the judgment. Offers are solicited and evaluated under an expedited timeline, with the receiver authorized to accept a bid deemed sufficient to advance collection efforts. These steps illustrate the broader strategy underlying the enforcement process. Rather than focusing on prolonged management or restructuring, the approach prioritizes speed, control, and the rapid conversion of assets into funds applied toward the judgment. Each action is grounded in court authorization, and each receiver operates under specific directives outlining their authority and responsibilities. Throughout this period, the Trump Organization retains no operational control over the seized assets. Decisions regarding staffing, leasing, maintenance, and financial management are made by the receivers, subject to oversight by the court. Trump and his representatives are notified of each action but lack the legal authority to intervene or reverse the process. As these enforcement measures proceed, they mark an unprecedented moment in the application of civil judgments against a sitting president's business interests. The focus now shifts from the legal arguments that failed at the Supreme Court to the tangible consequences unfolding in real time. In the next part of our coverage, we will examine the broader political and institutional ramifications of these actions, including reactions within the federal government, Congress, and the president's own administration, as the situation continues to develop.